During closing arguments, this attorney failed. He failed to object even one time. Would you like to know why that was the absolute right thing to do? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. I'm walking Daisy here, out for a nice little walk today. Hi, Daisy. So now, I was in court the other day. I had finished up a conference on a case I was handling, and now I happened to see another case on trial, and I walked into a packed courtroom. The defense lawyer was giving closing remarks in a medical malpractice case. This defense lawyer said a number of things that were objectionable. In my opinion, they were offensive. In my opinion, the plaintiff's attorney, the injured patient's attorney, should have jumped up out of his seat and yelled out, "Objection, Judge! That's totally improper." The attorney who represented the injured patient just sat there quietly. It was as if he was neglecting everything that the defense attorney was saying. It was as if he had earplugs in and wasn't even paying attention. The plaintiff's attorney looked like he was bored out of his mind. Meanwhile, this defense lawyer was a very experienced attorney. I'd seen him on trial many times, and many years ago I had gone up against him at trial. So I knew that this guy knew what he was doing, this defense lawyer. And I knew that he's a very good attorney, very articulate, has a commanding presence, but now was doing something that, in my opinion, I thought really was baiting the other attorney. I think he was saying things intentionally so that the plaintiff's attorney, the injured patient's attorney, would now make a big stink about these comments that were being made. And now, if he were to have done that, if the patient's attorney were to have jumped up, yelled out, "Objection, Judge!" And now the judge would ask, "What's the problem?" And now he'd have to explain to the judge and to the courtroom what the problem was. Then the defense lawyer would have a brief opportunity to respond and give a brief explanation about why he was saying these things. The reason why I said at the very beginning of this video that it was 100% right for this plaintiff's attorney to not go ahead and make a big stink about these objectionable things that were being said about his client was because he didn't want to draw attention to it. Now, during the middle of closing arguments, the jury looked like they were bored. They're looking at the patient's attorney. They see that he's bored, that he's not paying attention. If he were now to make a whole big deal about something that was just said by the defense lawyer, something that was offensive, something that was inappropriate, now he's calling attention to it. And if he yells out objection and the judge asks him for an explanation, now he's drawing even further attention to it. Plus, it gives the defense lawyer an opportunity to go ahead and now explain why he was making these comments. And you know what? In all likelihood, the judge is going to rule in favor of the defense attorney unless those comments are so inappropriate and so objectionable. At this point during closing arguments, the right thing to do, in my opinion, is to simply ignore it. Now, when the patient's attorney gets up to give his closing arguments, he can certainly comment on anything that the defense lawyer said. And that is the appropriate time in which to comment and to mock and to ridicule certain comments that were just made if he finds them to be offensive. And then he can show the jury that those comments are totally inappropriate and should never have been made. That's the right thing to do, and that's what I saw the plaintiff's attorney do in this particular closing argument, and in my opinion, that was the absolute right thing to do. Don't draw attention to it, there's no reason, and there's one other reason why there's no need to do it. Typically and customarily, attorneys do not interrupt each other during closing arguments. If something is being done incorrectly or wrong during closing arguments, then the attorney, the opposing lawyer, has an obligation on behalf of the client to stand up and make an objection for the record so that now the court knows that there's an issue. The court may have to give the jury a corrective instruction to ignore those comments. And why is that important? It's important because if the patient's attorney loses the case and now has to appeal, if it turns out he failed to appeal at the time that these things were being said, now the higher court, the appellate court, is going to look at it and say, hey, wait a second, the patient's attorney must have been asleep at the wheel. If he didn't object at the time, now he's waived his right to appeal that issue, and now he'd have to find other grounds to try and appeal the verdict. So why do I share this quick information with you? I share it with you because this was a fascinating insight into what was going on in the middle of closing arguments in real time, in court, on a real case. Want more information about how these cases work? I invite you to subscribe and follow me. Have questions about your matter? Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.